Ms. Padalano.
Good morning, Your Honor. The defendant, Mr. Arroyo, would like to thank this court for accepting his application for further appellate review. The case is very simple and straightforward, actually. It's amazing that it's taking this course, and I'll try as best as I can to respect the 10-minute limit on our argument. There's the first argument is to sufficiency, and there are a couple of important points. Even in the Commonwealth's brief, the only cite to evidence regarding the dates that the defendant reported are to the notices of surrender. And that's because all of the information, except for one date, about the dates that the defendant reported happened post-term. So for the reporting dates, Aquino also applies to the reporting dates.
If we should agree with you, I have a question about further proceedings in the case. Is this defendant being in custody now?
No, he isn't. He's on parole. So there's still a...
In other words, did he do his time as a result of the probation revocation proceeding?
Yes, he did.
And then he was
served
paroled from that
2.5
time?
years of the 3 to 5 year sentence. And he's on parole, which is slated to end July of 2010. So this
So
is...
if we agree with you, then he'll be taken off parole.
Potentially.
Well,
No.
It could be worse. I mean, quite honestly, we had long discussions about this case. He could have probation on remand. Probation term could be 4, 6. It's at the discretion of the year, the number of years at the discretion of the judge. It could also be time
No,
served.
I'm saying if we agree with you.
Yes, Your
Yes.
Honor, that's what I'm saying. On remand, then the judge would properly determine the disposition of this case on term conduct.
Yes.
And because of the time that he served, I don't anticipate that to be the case.
Yeah.
But certainly that is a possibility that
Right.
we have to be prepared for. So as to the reporting, there's certainly...
Agree basically with Judge Mills in the appeals court.
Absolutely. I was pleased not only to see that he understood our arguments, but it made it much easier to apply for further appellate review, because essentially I believe that Judge Mills was right in this case. The way that he distinguished the case from Aquino and said that, in fact, that there can be no consideration of post-term conduct. And here the record is replete with consideration of post-term conduct, not just for the arrest that occurred 39 days after probation ended, but also for the visitation information, for the testimony from the probation officer, again, that had only one date that occurred during term, and all the other dates were post-term. So Aquino should apply to that as well. It simply cannot be considered. The other, and the notice of surrender. Imagine if you could use the notice of surrender as evidence that the defendant violated the terms of his probation, and that is the only evidence the Commonwealth cites in its brief to support the reporting dates that there was sufficient evidence. If that were the case, well, then imagine the discretion that would afford the Department of Probation. They would pile on to the notices of surrender any information that they wanted to, knowing that they could use that as evidence. It's like using an indictment for evidence of a crime committed. It's simply, there's no case that says that, and I would appreciate that. I didn't ask for this in my brief, but certainly I would like it explicitly stated that notices of surrender cannot be used as evidence of a probation violation. It's simply used to give the defendant notice of what information, what the charges will be, but certainly it should not be relied upon as evidence in this instance. Secondly, the Commonwealth cites the confidence that Judge Locke had in the probation officer. And again, there's no case that talks specifically about judicial vouching in the context of a probation hearing. But certainly when you look through the transcript, and fortunately it's a very short transcript, the judge credits the probation officer above his reputation, above the evidence. And so the one bit of evidence about reporting fines, about the probation fines that comes in, which I believe is suspect, I don't think can be credited in this instance. The probation officer testifies that he sent a letter to the probationer, Mr. Arroyo, on March 15th. And in that letter, he told him about the problems that he was having and that there would be a hearing. And then the probation officer also said, oh, yeah, and sometime in March, I told him that he was late $385 in fines. Well, it is a bit suspect that, first of all, it was an objected-to letter because the defendant said that he never received a copy of it, and that the one specific evidence that the probation officer proffers is not recorded in this letter, when even the $150 reporting fee, which was paid post-term.
That was the counsel fee, wasn't it?
I'm sorry?
Counsel fee, wasn't it?
Counsel fee, yes, I'm sorry, Your Honor. The counsel fee is specifically noted in the letter.
Could I ask you a question? There's a reference in the majority opinion about this could be waiver because there was.
Yes. That was the
Can you
first
talk
time
about
it was
that?
ever mentioned.
I mean, I didn't see that the Commonwealth raised it in its brief, but
No.
but tell me about it. There was no objection to this, to the use of post-term information evidence at the time. Is that right?
No, there was no objection to. There was an argument that I believe there was an argument about the hearsay part of the evidence, but there was nothing specifically because Officer Mitchell, the probation officer, declared that probation had been extended, although it had not been properly, at least. So the probation date ended. The end of the term was April 4th. And when the probation officer testified, he said that he had kept probation open because of ongoing violations. And
So the hearing was conducted in the assumption on
Yes.
everyone's part that probation was an ongoing thing at that time. This was
Yes, Your
July,
Honor.
is that right? Is that when the
Yes,
hearing
it was July, and probation had ended in April. And so we did, I certainly thought about bringing in an ineffective assistance claim, but knowing how difficult it is and that it's a probation hearing, this is the decision, the tactical decision that I made. But again, I couldn't have been more surprised to have seen that waiver mentioned because it's nothing that had been mentioned prior. And so my argument also would be that that argument is waived because it hadn't been raised before by the Commonwealth. That would be the second part of the year. The third bit of evidence that the Commonwealth cites to, and this is at their brief on page 26 to 27, is the defendant's 10-year criminal history. And the one thing that is clear in probation revocation is that while the criminal history can certainly be used in determining the disposition, it can't be used as evidence in determining whether or not he did indeed violate his probation. And even in McDonald, it was said, undoubtedly the judge knew he could not consider information about the defendant's criminal history on the violation history, so, on the violation issue. And so that's pretty straightforward. So Aquino doesn't just apply to the May 13th arrest. It also applies to the reporting fines. The sufficiency of the evidence that, to the reporting, the sufficiency of the evidence on the fines is just not enough to hang a hat on, and that leaves the GED. And so then the final question that we have here is, interestingly, as I was thinking about this last night preparing for the argument, is one question that I didn't raise but would like to throw out here now is, similar to Rosado, which this court just decided a few months ago, if a GED is a condition of probation, what happens if not by his own volition or his attempts at trying that he can never get the GED?
But there's no evidence of that, is there?
No. And so then is it the point of, does the defendant have to provide the evidence that he's continued to take tests? Right now he's at the point where he has passed 4 of the 5 tests for the GED. So that was just something that I thought was interesting about this particular issue. But regardless of that, what we have left is failure to get the GED. And the question has to be, the critical issue is the abuse of discretion in determining the disposition here. If Judge Locke would the judge have exercised exactly the same discretion and come to exactly the same disposition if he had, instead of an arrest, failure to report, failure to pay fines, and the GED, or if he only had failure to get his GED? Would he have still sentenced the defendant to 3 to 5 years?
Right.
I just,
You don't question that he would have revoked probation.
well,
You're really talking about
I
the
believe that
sentence.
there is not sufficient evidence to revoke probation, but if you say that there is sufficient evidence, I believe, you know, the revocation is not the
discretionary
issue.
issue.
It's
It's the
whether he
sentence.
abused his discretion in sentencing Mr. Arroyo to 3 to 5 years for failure to get a GED. And when you look at the words of the probation officer, who he relied on so heavily, the probation officer says, and this is at page 96 in the transcript, "Granted, I understand that 5 years from defense counsel is a lot to request, but that is the maximum sentence I can recommend. But I'm taking into consideration the violent aspect of his ongoing case, the May 13th arrest that occurred 39 days post-term in the district court, which we found him in violation for, as well as the violent offense for which he was on probation in the first place." So it's certainly not the only thing that he's considering, but it's the primary thing that the probation officer talks about. And then in Judge Locke's own words, he characterizes it, the fact that you would willfully ignore your obligation to report, obligation to pay fees, and that while on probation you would yet again assault another person in this case, another person in some level of domestic relationship, words that the appeals court excerpted from their opinion, causes me to feel that incarceration is necessary and warranted. So for all these reasons, I believe that the best course of action, first of all, is to consider vacating this, one, because of the violation of his due process, and there simply is not sufficient evidence. But in the alternative, I ask that you follow Judge Mills' well-reasoned dissent and remand this case to determine a disposition that is not an abuse of discretion.
Thank you, Ms. Padilla.
Thank you, Your Honors.
Mr. Thomas?
Good morning, Your Honors. May it please the Court, Ann Thomas for the Commonwealth. As to the Aquino case, Aquino does not require an appellate court to remand should they find that a judge incorrectly considered post-probationary conduct in his ruling, where there were multiple properly found violations of probation. Remand is not required, and definitely Aquino does not hold that the lower court's revocation should be vacated by any means. In this case, there was sufficient evidence. I disagree with my sister as to the evidence concerning the failure to report. There were, over his probationary period, there were 2 surrender notices. Each had multiple amendments thereto, and in those surrender notices, in each one, it is a continual problem of failing to report.
What was the, other than the notices, what was the evidence?
The evidence is 2 things. The letter that was admitted as an exhibit that probation officer Mitchell had sent to the defendant, again, just further noting that you're still in violation, you're still not reporting, and also to speak to him again about certain fees that he hadn't paid.
The real problem here, it seems to me, which was pinpointed by Judge Mills, is that Judge Locke took into consideration his post-probation conduct, which I think is clear.
Yes.
He did.
Yes.
And if so, I assume you'd agree with me that he cannot do that.
Yes.
Okay. And if so, then this whole thing's got to be done over.
Well, I disagree that the whole thing has to be done over. The Commonwealth's position is that remand just was not necessary. It wasn't needed in this case because of the judge's detailed findings about the other properly found violations.
But it's clear, Ms. Thomas, that he's basing his decision on the improperly considered post-probation conduct.
But that might only require remand, not vacating the revocation.
But you said we should neither remand nor vacate.
Well, you're saying that there's enough legitimate stuff to justify the revocation.
Yes.
And we got to decide whether his reliance on the bad stuff, or it's nice, stuff he shouldn't have relied on, vitiates the whole thing.
Exactly. I don't think that's before the court at all. I think that
What do you mean it's not before the court?
That to vacate the lower court's order of probation revocation, the disposition that the judge then in turn found the 3 to 5 year sentence, remand for reconsideration of the sentence, but not whether revocation was proper, because there are multiple proper violations found that occurred during the probationary period that, again, the judge's findings are entitled to substantial deference.
But don't you think, taking what you say, don't you think that on remand, for whether it's Judge Locke or somebody else, in order to be able to figure out an appropriate sentence, you really have to hear what the violations are? I mean, so you really have to have the whole hearing again. Because you can't, it's just a different, it's a different evidentiary scene if you extract particularly the May 13th event, but some of these other problems as well.
Well, I disagree respectfully because of the fact that the findings were so clear. And the other thing that we're forgetting is that the evidence...
Ms. Thomas, the finding, I mean, do you, I wasn't clear what you were objecting to in Justice Botsford's question, that there doesn't have to be another evidentiary hearing?
No, I don't believe that there needs to be, because what we're forgetting is that Officer Mitchell, Probation Officer Mitchell, testified. That was evidence before the judge, and that was a credibility determination on his part as to the support for his surrender notices and for his repeated notifications to the defendant that he is not appearing on a regular basis. He's failing to appear. And then also his fee violations and his GED.
If the notice of surrender cannot be considered as substantive evidence, and you would agree with that, correct?
I don't agree with that.
You don't?
Not at a probation revocation hearing.
A notice of surrender can...
Just by itself can be evidence?
No, in connection with Probation Officer Mitchell's testimony concerning those violations and why he sent them, and as to the defendant's reporting history. The part my sister is referring to is...
Yes. If we looked at Officer Mitchell's testimony, would it be clear from his testimony, because we know that the notice of surrender includes lots of post-probation conduct,
Yes.
would it be unquestionably clear that he is testifying to only during probation conduct?
He is not testifying only, no.
Well,
He testifies...
then surely we have to have another evidentiary hearing.
Respectfully, I disagree.
Why?
Because his
How
testimony
is-
as to his interim conduct...
But if you can't tell,
But you can't-
if he's not distinguishing between interim and post-probation,
No, then I misunderstood your question. It's not that he's not distinguishing between the two, which he does very clearly. It's that he testified to both. He did. So he testifies to a continual problem of failure to appear and how he notified the defendant of that through these notices in his letter. Then he testifies, and these were for the period of time after that were not covered by these notices in the letter. The letter's dated March 15th of 2005. And the period was to end April 4th. So there was no more communication.
But the question is, if you take out the post-probation stuff, which you agree is bad, the judge may not have violated him. Are we sure he would have violated him on the other stuff?
But yes.
How do we know that?
how do we know that?
I think it's clear that he would have violated him. As to what sentence he would have
How
gotten,
do we know
No, but how do we know he would have
because
violated
of the
him?
judge's words where he said that he specifically, and that's the part that I disagree with the dissent, and I agree with the majority in the appeals court, is that the judge was distinct in making that these were not technical violations, because there is no such thing as a technical violation. These are all conditions of probation, and they're all, other than the first one, which is to obey the laws of the state, which everyone has to do, the rest are just for probationers.
So did the judge say something? Did he say these aren't technical, or what did he say?
He said that, and I'm sorry, I should have it more at my fingertips. He said that I'm sorry, the fact that you would willfully ignore your obligation to report, your obligation to pay fees, and then, yes, he goes into the post-conduct of the actual violent offense. He says, causes me to feel that, well, then he goes on to incarceration. But what he says is that defendant's refusal or noncompliance with relatively easy terms of probation. He goes on to say that probation is your time to show me that you can be responsible and productive, and you have failed to do it. He is not working either at the time. He wasn't.
I agree with you that absolutely, on its face, there certainly is reason to revoke probation, no question about it. I guess the trouble that I'm having, though, is because just in reading what Judge Locke said, he has talked about those violations, also talked about the May 13th. It just seems to me that it would be a cleaner, fairer sort of proceeding to sort of have in front of you in one place what you can consider and then make a decision about what is the appropriate disposition.
Well, and I do feel that he can do that with the record before him, the transcript of it, and if the judge, again, says, I have reviewed everything that was before me, I now, based on only conduct that occurred during the probationary period, find, and then he can make his finding whether he would again revoke, and if so, what the sentence would
When we
be.
used to reverse for sentencing, we didn't do it that way because it's very hard for the judge who's been told he did something wrong to say, well, based on the right stuff, I'm going to impose the same sentence or
Well, he couldn't do that.
No, I'm saying that
He
he
could.
could
He
have,
could.
he could
but
just
it would
use
be-
the
you
evidence that
can't
was before
impose a
him.
larger sentence because that would be vindictive.
Right.
But it would be very hard. It would be.
But he could impose the same
He
sentence.
could
Of
impose the
course.
same. It would be rather extraordinary.
He could also extend probation.
Yes, he could. Yes, he could. So, all righty.
Thank
There's
you.
no further questions?
Do we take him out of the equation and assign it to another judge if we decide there's error, just to take that pressure off of him?
Well, as a
Think-
practical matter, that may be the result because he's in Brockton and this is a Suffolk case, so.
And I know the first probation revocation proceeding for the same,
We can always
for
come
the
back to
defendant was a
Suffolk
different
for a
judge
day.
also. Thank you, Your Honor.
Thank you, Mr. Thomas.